Luzira Maximum Prison built to house 8,500 inmates, but currently there are more than 20,000 incarcerated in here waiting trial. Majority are petty offenders.
Petty offences, as I understand them, are smaller offences punishable with a fine, a small fine, or imprisonment of not more than 1 year, really.
In Uganda, petty offences are provided for under idle and disorderly laws found in the Penal Code Act, Cap 120.
We got it from the colonialists, and then we are using the same provisions to control those who are worse off in society. So we have a new class of people that replace the colonialists, the rich, the middle class, and then they want to use these laws to eliminate people in a particular class of people. Those are regarded as poor and unacceptable. So for me, that's a matter of great concern, that should we have laws on our law books that are intended to just criminalize a particular group of section of society.
Some of these laws are rogue and vagabond, or what you call common nuisance. They all lie under rogue and vagabond, idle and disorderly. There are laws such as fouling air. There are laws relating to selling in a wrong place on a street, or they relate to street vendors. And when you look at these laws, there are laws where the poor people, the indigent people are trying to make a living.
It's upon this background that the Human Rights Awareness and Promotion Forum Uganda, HIRAF, and other human rights actors working under the coalition to decriminalize and declassify petty offences have embarked on this difficult mission to expose the human rights violation associated with petty offences and call for public demand for decriminalization of petty offences.
But we also thought that it would be better that as we are fighting against these laws, we have a combined voice of national institutions come together and talk about these issues. The
Constitution of Uganda provides for equality. It provides for non-discrimination and equality, and it provides that no one should be discriminated against on different grounds, including economic and social status. The things are covered. So these laws are actually discriminating against a group of people based on their social and economic status. And that's why these laws are dangerous and should be decriminalized. That's why we are part of the coalition to decriminalize and declassify petty offences in Uganda, CODIPO. That's why we've taken cases to court challenging the enforcement of these laws and challenging the existence of these laws on our law books.
We had an incident where a judge was arrested, and they asked him, can you explain yourself? And he said, I'm a judge. And the police officer said, I'm the Pope, because he thought he was lying. Because on an ordinary day, he's not wearing a suit. As a judge, he does not look the part of a judge who was going for a walk in the evening. So when they were sweeping the streets, they swept everyone, including a judge himself.
There is usually aggression in the enforcement by law enforcement agencies. They've also raised concerns of discriminatory behavior, where certain sections of the public are targeted, especially those that are vulnerable, poor, on the low side of society, and again those who are above average and on the higher side of society are not targeted.
In Mugu Parish, Buama Rural, Kalyango Israel went on about his day as usual. Little did he know that it would be a long time before he sees his family again.
Kati nze kwolwo nali nina bizinensi yange gye nali nkola wano mu tawuni waffe Nabyewanga, era naggalawo ng'obudde bukyali ne ntambula nzira ewaka wange. Nagenda okulaba nga ndaba ekibinja ky'abasirikale ab'amagye baali bawerera ddala 6 nga balina n'emmundu. Bwe bandaba ne bantaayiza, nange ne nnyimirira ne batandika okwagala okunkuba, bambuuza gye nva. Mbagamba munkuba nziziza musango ki, nkoze ki? Ne baŋŋamba tukukutte kafiyu. Ne nzigya essimu yange mu nsawo ne nkebera ku ssimu nga ziri essaawa 12 n'eddakiika 31 ez'akawungeezi. Nga mmanyi nti eddakiika nga we nnali we bankwata eddakiika 10 zokka zaali zimala okutuuka awaka. era n'alituuse nga essaawa emu tennawera ng'ekyabula okumpi eddakiika nga 10 n'okusoba. Abaami abo baŋŋamba tugende tukutwala tukukutte omenye etteeka lya kafyu. Ne bantwala ne banteeka kabanga lya poliisi ne tubeera awo nabyewanga ku poliisi. Zaali ziwera ssaawa ndowooza nga 5 ez'ekiro ne batuvuga n'abalala baali bakutte ku ttoomo ne batuyita ne tugenda batutwala mu kkooti ne batandika otusomera ffeero zaffe ne batusomera emisango egyatukwasizza.
On 9th April 2020, Israel was taken to Chitalia prison.
Kati omulamuzi n'atugamba nti mugende Chitalia mujja kukomawo ng'ennaku z'omwezi 12 omwezi ogwokutaano bwe mujja okukoma mu kkooti nga tewali kyakola ne tugenda Chitalia.
Very many Ugandans on a daily basis are arrested by police and taken to various police stations. You will discover that if there is there will be an operation, for example, pick prostitutes from the streets, and what laws is police using to invoke? I mean to facilitate these operations, being idle and disorderly, being a rogue and vagabond.
Israel had hoped that perhaps in a few days he would be released. He later discovers that his hopes are in vain.
Naye ng'ennaku z'omwezi ziri batugamba omulamuzi yatugamba kudda mu kkooti nga 12 ogwokutaano tebaatuyita era tetwaddayo. Ogwokutaano gwaggwako nga tebatuzizaayo teri kanyego, ogw'omukaaga ne gutandika mpaka lwe gwaggwako nagwo nga tebatuzizaayo mu kkooti. Tuli eyo tubona abali.
Ekyokumisinga kkooti si mawulire. Era tekiri kugamba nti babakutte nti ogenda kugenda mu kkooti ng'ennaku z'omwezi bwe ziti tebajja bakupikinga ogende mu kkooti bakweyimiririre. Ekyo tekiriiyo. Osobola okumalako obusibe bwo ne weeyongeza namwe ennaku ng'oli Chitalia. Ne batukukuza mu kkooti omulamuzi okusoma nga n'ennaku waziisaamu ze balina okusiba.
The system falls short of standard in allowing consular visits for detainees and setting dates for hearing these petty cases. Sometimes they do, most times they don't. It all depends on the price of the prisoner they hold.
Kkooti 47 ziteeka abantu ekitali awo. Kizibu kya muntu muzzaayo olunaku lwagenda mu kkooti. Muyinza okuba mugenda basatu oba bana. Wava oba wava eyo ludda oba laakaayo oba wa. Kati teyinza kkooti gamba nti muleete omuntu oyo teekamu entambula ekola ki? Emuleeta. Obuzibu bwajja nti abantu balinanga kkooti okumpi nga bebaga nti ojja kudda ennaku z'omwezi ziti nga bakuleeta. Naye ekitali tekiriiyo. So bw'ogenda ekitali ogenda mu kkooti osooka n'obya n'okola ki? N'obyesonyiwa.
On 30th June 2020, Israel is released. But what is it that convinced the prison to allow him to be discharged?
Kubanga abantu ebweru baali babataddeko akazito, nga gavumenti bagitaddeko akazito, abantu batandise okwekalakaasa, abantu bibi nnyo. Abakazi bakaaba, ababbaabwe babasiba, bali mu nnyumba mpangise, tebalina kyakulya, tewali kikolebwa. Ebituusa gavumenti yasalawo nti abantu bakole ki? Ebate abakafiyu. Naye era mu kututa baatuteekako obukwakulizo. Kubanga baamanya nti waliwo abantu be bankutte mu nkwata, be bankwata mu nkwata eteri ntuufu, abajja okuvunaana nga bafulumya ebweru. Ekyo baakimanya. Kati kwe kusalawo ne bateekako obukwakulizo ne batugamba nti buli muntu yenna nga bakukwata kafiyu, oba bakwata ssaawa 9 oba bakwata ssaawa mmeka, olina okukkiriza nti bakukwata ng'omenya amateeka ng'essaawa za kafiyu zituuse. Bw'okkiriza nti omusango gukusinga, ogukkiriza nti bwakusinga nga tukuta. Bw'ogaana okukkiriza n'ogaa nti bwe tokkiriza weemulugunya enkwata gye bakwatamu n'essaawa ze bakwatiramu nga tukuzzaayo.
Human rights organizations have advised that petty offences be decriminalized, but unfortunately, they are not decision makers.
As Parliament, we should have done our role a long time ago to ensure that the laws are amended and we get rid of the petty offences. Government is equally guilty because legislation, the legislative process, primarily begins with government. Government should bring bills in Parliament. But if government does not do their part, the executive for that matter, then Parliament ought to do its part. So the fact that Parliament has not done its part, the fact that the executive has not done its part, only shows that as a country, we have let down the people.
In October 2019, there was a presidential directive to the Attorney General to repeal the idle and disorderly laws from the law books.
Currently, we are trying to amend, we are proposing amendments in respect of the the lawyers call the MCA, the Magistrates Courts Act, the TIA, Trial and Indictments Act, the Penal Code Act, the Criminal Procedure Code, and those are the laws relating to criminal practice in the courts.
Unless the state can intercede and modify this law, thousands of taxpayers' money will continue to be spent on petty offenders being incarcerated in prisons without trial. Yet these detainees could pay fines or serve their sentences.
We need more beds in prisons that we don't have. We need mattresses, so they end up sleeping on the floors, and we end up having crowds in prison for cases that don't need to be there. Cases where we can find alternatives and say, can you, okay, yes, you threw a paper on the street. Can you sweep the street? Can we change the attitudes? Can we change? So implementation then becomes a challenge. It's also a challenge by law enforcement themselves.
There is a backlog of cases, but what does it take for these cases to be tried?
One of the factors is the human resource. Right now, we have the High Court judges we have are 57. One judge might be handling over 500 people. That one person cannot handle the situation. Now, when you leave that, you go to the resources. You need lawyers, because every case in that session must be represented by a lawyer. Every accused person must have a lawyer. If he can't afford, then the state puts for him a lawyer at a pay. So that is money. Witnesses who come to attend the High Court session must be paid transport, and sometimes they are accommodated. We have expert witnesses, doctors who come to testify in court. They must be facilitated. So when you look at all that, you find that the court sessions that have to be held will be limited in number, because the resources are not there to have as many as can be. At the end of the day, backlog.
Even if lawyers were to file a lawsuit, getting evidence and establishing the truth would also pose a challenge to the courts. The result is a case filed with a single charge, idle and disorderly.
The thing you're criminalizing should be clear. It should be definite, and I should be able to understand what I must do to avoid violating the law.
For example, if you arrest someone who has snatched a bag or snatched something from someone's car, that is theft, right? They are not rogues, but they are thieves.
A petition was made challenging a section that provided for petty offences in the Penal Code Act of Uganda. The petition is Francis Tumwesige Atenyi versus Attorney General Constitutional Petition number 36 of 2018. It challenges parts of the section of the Penal Code Act that creates the offence of being a rogue and vagabond, particularly those parts that make it a crime to wander upon a highway in suspicious circumstances.
This element of suspected person or reputed thief, according to us, violates that fundamental principle of our law, which is the presumption of innocence, because then our people are liable to be arrested on a suspicion that they are thieves or they are reputed thieves, and that suspicion is not before a court in terms of a charge. It's not been a person has not been indicted. So it's so fluid, it's so difficult to define.
The petitioner wants court to declare the offence of being rogue and vagabond as defined in section 168, 1C and D unconstitutional for being in contravention of the Constitution.
We need to get these laws off our law books, of our penal code. Even now that even the highest office holder in the country has recognize that there is a problem with the laws and suspended their implementation, why then do we have to keep them?
Now we need to see how best to either amend the laws to run with our current times or to repeal them without necessarily injuring the remaining laws, without necessarily impeding the working of government. But most importantly, what we look at in these laws are the rights of the individual.
We have drawn a roadmap. We have reached out to different government agencies and said, how do we do this? So we have reached out to Ministry of Justice, we've reached out to Parliament, we have reached out to Law Reform Commission, saying, because we need a buy-in by the state itself and government agencies. The implementers, DPP is on board, police is on board.
So it is Parliament, basically, that is maybe moving slow as far as the process of repealing some of these laws is concerned.
Prioritizing petty offenses could be extremely difficult. So we need lobbyists, we need stakeholders, the media, the NGOs and other, members of society to campaign for decriminalization.
Israel and a host of others are powerful witnesses to the dangerous law that threatens our country's judicial system.
I would call upon all Ugandans, not just lawyers, not just middle class people, not just the poor, but every single person in this country, because the violation of my rights should also be a violation of your rights. If I'm violated, then you are also being violated. You can't sit and say, for me, I'm okay. It's just those people. If we sit down and do nothing, then we are losing the whole struggle for equality and justice. So I'm calling upon every single person. I'm calling upon civil society. I'm calling upon state institutions. I'm calling upon individuals to come and join us as we fight this. Come and join the coalition to decriminalize and declassify petty offenses. Come and speak out loud so we can have that struggle for equality reach the maximum level it can reach.